as the indictment says, they're not attacking his First Amendment right. He can say whatever he wants. He can even lie. He can even tell people that the election was stolen when he knew better. But that does not protect you from entering into a conspiracy. All conspiracies involve speech, and all fraud involves speech. So, free speech doesn't give you the right to engage in a fraudulent conspiracy.
Hi again, everyone. It is 5 o'clock in New York. I'm Alicia Menendez in for Nicole Wallace. It's a defense we're hearing from Donald Trump's legal team and from his defenders on the right. The ex-president's conduct around the 2020 election result and the lies he spread about voter fraud are protected by the First Amendment. But it's a claim Trump's own hand-picked former Attorney General Bill Barr believes has no merit. Jack Smith made sure to anticipate this defense, saying up front in the indictment that Trump had every right to speak publicly and make false statements. But the former president went beyond that, committing unlawful conspiracies. Smith says, quote, each of these conspiracies, which built on the widespread mistrust the defendant was creating through pervasive and destabilizing lies about election fraud, targeted a bedrock function of the United States federal government, the nation's process of collecting, counting, and certifying the results of the presidential election, the federal government function, meaning it was the former president's actions, not his words, that Trump is being charged for. As our friend and former U.S. Attorney Barbara McQuade put it, Trump's First Amendment defense is a loser. Conspiracy, threats, extortion all involve speech, but all cross the legal line. No right is absolute. By this logic, all Osama bin Laden did on 9/11 was engage in speech. Agreeing to commit a crime is a crime. And Axios provides this context. The First Amendment would have played a bigger role here if the special counsel had charged Trump with directly inciting the January 6th riot. Political speech is heavily protected by the First Amendment, and it is extremely difficult to convict someone of inciting violence based on their protected speech. But that isn't a charge in this indictment, which may well be been a strategic choice by the special counsel's office. A reminder of the 4 federal criminal charges levied against the ex-president: conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights. At yesterday's arraignment, Trump pleaded not guilty to all 4 counts, and the first pretrial hearing was scheduled for August 28th. That is just over 3 weeks away. And that is where we start this hour. Let's bring in Professor of Law at the University of Utah and First Amendment scholar Ronell Anderson-Jones, plus State Attorney for Palm Beach County, Florida, David Arenberg, former Deputy Assistant Attorney General and former U.S. Attorney Harry Litman, and former Congressman from Florida, MSNBC contributor David Jolly. Friends, it is good to see you all. Ronell, I want you to break down for us why Trump's First Amendment defense is wrong here.
Yes, well, the indictment rightly acknowledges that Trump had a First Amendment right to talk about and even to lie about the election. The Constitution does broadly protect and broadly guarantee that the government won't punish us for our political speech, even if it's false. But speech is routinely used as evidence of other criminal activity that the government can and must punish. So, for example, if you were charged with conspiring to rob a bank, you couldn't invoke a First Amendment defense on the grounds that you were exercising your free speech right to tell the getaway driver to come around back or to tell the teller to stick him up. And the Supreme Court has made clear that it is absolutely constitutional to punish things like fraud, even though the main tool that the criminal will use to scam his victims is speech. The DOJ here is going to argue that Trump's case is the same. It will point out that the indictment here is for participating in a large-scale conspiracy, an electoral fraud, and for entering into agreements with other people who were a part of planning that criminal activity. We would expect that some of the evidence there would be communications, would be speech, but that wouldn't involve any sort of imposition on anybody's freedom of expression. The DOJ is for sure going to want to be cautious here, and I think that they have been incredibly cautious, recognizing that this is a constitutionally and politically sensitive case. But a great body of First Amendment doctrine and all of common sense teach us that you don't get a free pass to commit crime just because you chose to commit some of those crimes using some words.
Ronelle, to this point about how First Amendment protections would play a bigger role if Jack Smith had charged Trump with the incitement of the Capitol riot, can you expand on that? And I wonder if you expect a superseding indictment from Smith coming at some point that would charge him with incitement of an insurrection.
Yes, an incitement charge would be a much more thorny First Amendment matter than the charges that have been brought so far. Incitement is one of a very tiny number of categories of speech that have been carved out of the protection of the First Amendment by the Supreme Court, and it's very, very narrowly defined. We use the term colloquially to sort of mean people urging other people to take actions, but the Supreme Court has defined it in a very specific, deliberately speech protective way, and it has to be the case that you directed your speech to inciting imminent lawless action, and that you were likely to incite or produce that action. It requires some evidence of what you meant to do, and also some evidence about timing, a sort of immediacy of timing, all of which are very difficult to prove up and quite constitutionally fraught. So while we might ultimately see some incitement charges coming, you can see why, as a First Amendment matter, Jack Smith chose to proceed in the way that he did with charges that really here in the current indictment don't touch on sticky First Amendment issues of that sort.
Right. So, David Shelley, here's the thing. Since this defense doesn't hold actual legal weight, I wonder then if we need to be thinking of it more as a political argument, as the type of thing that is meant for Trump supporters to repeat on a loop over and over again, regardless of its merits.
Yeah, I think you're exactly right, Alicia. I mean, we're all well aware that Donald Trump is trying to litigate this in the court of public opinion, seek some type of political absolution for the peril and jeopardy he now faces through the criminal justice system. But that doesn't hold any weight in the criminal justice system. He can convince as many of the Republicans as he cares to that he has a free speech defense. But as we were just hearing, it doesn't hold weight in the court. I do think two things are obvious. One is this was a well-coordinated effort on behalf of Donald Trump and Republicans to get this message out there immediately. They had their talking point ready. It's been amplified by Republican leaders on the Hill and even at the highest levels of Republican leadership. I think it also indicates a second thing, though, which is Donald Trump and Republicans are several steps behind Jack Smith and several steps behind where the nation knows this is going. Because this argument, if this is the best they have, is so easy to penetrate. It does suggest that Donald Trump right now is not up for either the legal fight nor the court of public opinion.
Harry, there's another defense that is being circulated that if Trump actually believed the claims he was making about election fraud, that could protect him. But you wrote a piece in 2022, it's like you were clairvoyant here in the LA Times, saying this is not true. You use the example of the ex-president's call to Brad Raffensperger to make that argument, writing, quote, "What Georgia legalese drives home is that even if Trump pressured Raffensperger under the sincere belief that he'd won the state, it was wrong, indeed criminal, to twist the arm of the Secretary of State to get him to alter the count. Trump's lawful avenue of redress was the legal process and the state courts." Talk to me, Harry, about how Trump's beliefs are not what's at issue here.
For a few reasons, but starting there, right? Let's say he had that sincere belief, so he decided to, I don't know, shoot Joe Biden in the head. It wouldn't insulate from it whatever he had in his mind, and it would justify him to go to court. He did it 60 times and lost, 59 and a half of them. So that is the principal point. It's also something they just don't have to prove under the law. He's made, as the professor just said, and Barbara McQuaid and Bill Barr, how much more agreement do you need than that? You make an agreement to do something unlawful, like rob a bank. End of story. It's a very lousy argument. This one, however, I think is going to be maybe less an argument than a kind of overweening theme that is going to be a little bit hard to get your hands around here, but what might potentially, they hope, sway some jurors. It's got both sort of legal purchase that doesn't hold up and then a kind of atmosphere that they hope does. Poor Trump, he really believed it. You know, he's so nuts, he convinced himself, et cetera. Shouldn't matter legally, but you can imagine jurors actually thinking of it and generating some sympathy.